And Mr. Pruner, this is your motion, so I'll let you go forward, okay?
Thank you, Your Honor. The factual basis and the reasons for the motion are set forth within the body of the motion, simply stated, as this court and this community is aware, an arrest has recently been made in connection with what has been referred to as the Southeast Seminole Heights murders. That individual is a defendant by the name of Howell Emanuel Donaldson III. That individual is the natural son of Mr. and Mrs. Donaldson, the subjects of the motions for order to show cause. As set forth in the body of the motion, the state of Florida, pursuant to its statutory authority under Florida Statute 2704, issued a subpoena upon Mr. and Mrs. Donaldson, or I should say subpoenas, within our broad authority to summons witnesses to assist us in an investigation into a violation of law. The Donaldsons did respond, and on the date and time directed and commanded in the issued subpoenas. They were represented by counsel. Sworn statements were attempted to be taken of Mr. and Mrs. Donaldson separately. Some biographical information was obtained, very minimal, from both Mr. and Mrs. Donaldson. However, in response to continued questions pertaining to matters of substance that address interests of the investigation, both Mr. and Mrs. Donaldson refused to answer. I have set or attached as Exhibit B to each of the motions, and Mr. Harmon, I should say, attached to Mrs. Donaldson's, the motion referenced Mrs. Donaldson, the transcript of the proceedings that day, where it's very clear that they refused to testify, despite the explanation to them of use and derivative use immunity as that is self-enacting under 914.04, that they did not have a right to refuse to testify. Nonetheless, in the face of those explanations, it became clear that they were going to continue to refuse all questions posed of them by me, and as it pertained to Mr. Donaldson and Assistant State Attorney Scott Harmon, as it pertains to Mrs. Donaldson, leaving us with no recourse but to file these motions for orders to show cause, compelling their testimony or, in the alternative, sanctions. But there is a procedure and a process and due process that is required as set forth by statute. And this is the first step in that process, Your Honor. So we're asking, Your Honor, to refer to the motions filed, the affidavits filed, attached to and made a part of the motions, and Exhibits A and B to each motion, which are the subpoena returns and the transcripts which reflect and form the basis for the motions for order to show cause, indicating that there are a willful refusal to testify despite being issued lawful subpoenas. The state's position is there is no privilege derived from either Constitution or statute which allows them to avoid answering questions, and that their willful failure to answer questions is a contemptuous act of the authority of this court, as these subpoenas are issued under the aegis of this court. And so we are asking that this court issue an order to show cause, commanding both Mr. and Mrs. Donaldson to appear before Your Honor and to state why they should not be held into contempt, or in the alternative, why they should not be compelled to answer.
Excuse me one moment. If I could have everyone at the jail, can you guys turn off your mics, please? We're getting a lot of feedback here. Thank you. All right, so Mr. Pruner, just to help the court to clarify the issue a little bit, what is the goal that the state is seeking specifically? Do you want the Donaldsons to answer your questions?
That is the goal. We are seeking to to conduct a thorough investigation of the matters involving the violent loss of 4 lives. And as our statutory obligation and our ethical obligation dictates us to exhaust every lawful investigative avenue, we are seeking testimony that would only be within Mr. and Mrs. Donaldson's access and knowledge. And so that's the purpose for this motion. Ultimately, that's our intent and our hope. They would comply and answer our questions.
So you're seeking the court's intervention to assist in answering the questions as opposed to the court's intervention and to punish the Donaldsons. The goal from the state is to get the questions answered. Is that correct?
That was the goal from the date we issued the subpoena, and it remains our goal, Your Honor, for clarification, and I may have been ambiguous in an earlier statement. Most immediately, our goal today is just to ask this court to issue an order to show cause compelling Mr. and Mrs. Donaldson to appear before Your Honor and answer why they should not be held in contempt, and to seek the court's intervention in directing them to comply with their legal obligation.
All right, thank you. Mr. Fernandez?
Yes, Your Honor, thank you. Would you like a seated or standing?
Whichever you're more comfortable with.
At my age, I think I'm going to sit. First, I apologize for late filing today. We worked through the night on this, and we made reached conclusions and so forth and filed our response, which I hope by now is part of some record, and I apologize if you don't have a copy.
I have copies.
All right, and we provided very late to my most collegial adversary a copy in the hallway, so I presume that they would have a response if they were given the time. There were 2 housekeeping matters that I thought worthy of reference because of the significant coverage afforded this case, which impacts a lot of the issues that are being presented here. I'd like to begin because I was a tad troubled by a statement that was made by one of the prosecutors, not Mr. Pruner, in the inquiry of the mother of Rosita Donaldson, and I believe the quote has something to go along the lines that the lawyers are not allowed to interfere with our investigation. Now, Mr. Pruner, I know, would never make such a statement. We're not interfering with any investigation, and I want the record to reflect that Mr. Guzman, Mr. Shafi are seasoned veterans, and they don't interfere with investigations. So I hope in the future we try to work together, as Mr. Pruner and I have for many years, and hopefully Mr. Warren, who I've never had the pleasure of meeting. The second thing is that I woke up and got a little concerned when I read an article today referring back to a historical case, the Porter case, Jennifer Porter case. And because of the opposition in this motion, I think that I don't want anybody to misunderstand the gravamen of the situation nor the seriousness of the way that we handle our matters in view of the existing authority, what we think should be the authority, cases of first impression, and likewise cases that impact, I think, the conscience of this nation. There's a reference that in the Porter case that I did more or less the same thing many years ago when the parents were summoned to testify, and that they invoke their rights and refused to do so, and 3 days later, however, things changed. Well, they did, because I did not represent them 3 days later any longer. I don't come here like as a ruse for something later. So I wanted to say that because one of the things, and we agree on many things, and this is a very difficult case because of the fact that from the inception, that's why the Donaldsons have been devastated, not only for the personal tragedy, but they have extended their condolences repeatedly to the victims that suffered greatly, that it's unimaginable, and they reached out both in prayer and in their expression. Likewise, the community of Seminole Heights that was held hostage, likewise even to the city of Tampa, its mayor, and law enforcement throughout. And so this is part of this very tough situation, because the reason it plays into where we're at now is because of something noted in there, that they haven't slept, that they can't function, that they can't think cogently and clearly, that they're confronted with a proposition that very few ever have had to, that they feel hostages in their own home, that they've considered leaving town, that they have a younger child, they're afraid of the safety. Just this morning, I received one of a battery of emails that I have received in my office, and you know, there have been communications directed to them, impacting, in other words, their thought processes by threatening them with death, and their written communications. And so, rather than be more divisive and creating more conflict, then we've decided to ignore the opportunities that people suggest we take quickly and radically to resolve this problem. Mr. Pruner and I just briefly, as he stands on the other side of the screen or sits there, but we just decided that to chat a few minutes. We always have, even in the toughest of cases, the Rule 3840 process, and that is delineated, you know, clearly, that this is a first appearance, at which time, with or without opposition, this court can enter the rule to show cause, and then it goes to the necessary secondary phase in Part B of the rule, even the responses, motion, statement of particulars, partial discovery almost implicated in it. Likewise, then there's an arraignment, a hearing. So this is not a, today is not a, you know, technically a trial, but the reason, because of the nature of the case, and not suggesting that this court would not follow the rule, but having seen everything in so many places, both here and far away throughout this country in cases, I want to make sure that we had something on the record already addressing these issues because of the critical problems that we face in the case. So, admittedly, they knew when they went that they were not going to answer questions that would lead to the execution of their son. And that would be something that we may have to deal with, because that has an impact. And I'm not suggesting they have any direct knowledge, but then I'm not suggesting that they don't, because then why would the state call them and bring us before this court if they felt that they had no actual knowledge? So it's implicit, you know, in a lengthy practice, that the reason we're here is because, and still here today, and still addressing the very issue, that they want something from them that will perfect the case so that perhaps their son is executed. And, you know, it's one of these concepts that is very difficult for, I think, any parent. And a lot of parents, you know, will say, you know, I agree with you, you know, I can understand that. But, you know, the law is the law. But that is until it happens to their child. And then from Pennsylvania Avenue yesterday on down, we know that the tossing of the privileges is rampant, unbased, and unfounded in part. And so what happens here is that the nature of the questioning that we engaged in, and I told Mr. Pruner, and again, it's hard because it's easier to deal with a prosecutor that is not as professional and collegial. Frankly, it's disarming to have this across from me. I'd rather have it the other way, where the tempers flare from the inception, but that's not the way it is. It's also great that he knows law. And so when we spoke, you know, I from the nature of the questions and so forth, I perhaps said we'd live to fight another day in the case, and perhaps agree or disagree as to some of these issues. But, you know, I have framed the response. I have been candid, I hope, or shall I say Ms. Edwards from our office has been candid, I hope, in the expression that the position I take, if it gets to some of these things, is a minority position, but, you know, letting kind of the cat out of the bag, which is the process before this court, the threshold questions, and after the notice I gave him there would be no answers to the questions of substance, we can't even evaluate the real privileges that may lie, that are enumerated in Chapter 90. And the reason is because there may be spousal privileges that need to be overcome. What if there were discussions between them about observations, not necessarily about acts or evidence? What if they formulate opinions unfounded in medical evidence of any sort that they discuss? So all of that would follow to perfect something that I don't know. But I can assure this court that the community interest in finding out what happened is equally as important, and most good lawyers would say not as important, but it's equally as important as the preservation of due process in the case and the Donaldsons' ability to reflect upon some of what is taking place. And Mr. Pruner was efficient in terms of their condition or his condition when I was present. The transcript likewise reflects the same for the mother, to establish whether there were any problems and so forth. But Mr. Pruner, thanks, I guess, in part to my, I wouldn't call it interference, thanks to my position, was unable to ask a question such as, have you slept for 4 days? You know, do you know where you're at? Meaning, like, and things of this nature that likewise would have led perhaps to another inquiry. And I know he's professional enough to do that. So we would have objections to the final goal, because no matter how it's perceived, it's testimony that is being elicited to make a determination about the life or death for their son. You have everyone on one side, I guess, that wants answers. The problem is how to cogently, fairly, and efficiently arrive at those answers, because let no one believe that the parents don't want answers. At the same time, nothing that I say is to impact the guilt or innocence phase of Ms. Holt's representation. I've made it abundantly clear, by the way. And I did want, as I close, to alert the court to how, you know, this particular, and also Mr. Warren, who's again behind the screen, and I'm sorry that I'm not having eye contact with you, but to alert him to the fact that how this came about in the selection process, which is accurate, and many people suggested that they wanted to be part of this team, would fund this. A lot of the old legends that, you know, over the years we have met in courthouse steps and so forth. And so then I had to look at the best team available. And it's a local case, it's a local matter. And so that's why I selected Julianne Holt and her staff. So I don't, now having delegated, shall I say, that responsibility, I certainly don't want to say anything that would impact their case. Thank you, Your Honor.
Thank you. Mr. Guzman, Mr. Shafi, any follow-up?
No, Your Honor, we've provided the state, and I believe, Your Honor, with our motion to adopt the facts and arguments that provided by Mr. Fernandez. And once again, on behalf of the family, you know, they understand. They are very sorry about everything that's happened. Everybody's a victim in this matter. And it's been a very harsh reality that they've had to live in, and repeatedly they have expressed their sorrow to the community, to the victims, to the individuals, to the police force, and to the Seminole Heights community.
Mr. Pruder?
Just in brief response, Your Honor, I would emphasize that the only issue before Your Honor today, and the only inquiry I suggest before Your Honor to resolve, is whether the state's pleadings and the exhibits attached thereto set forth essential facts, in this case, the Donaldsons' refusal to answer questions that would potentially comprise indirect contempt. And we would ask Your Honor to make that finding today based upon the pleadings that have been unrefuted at this point.
And Your Honor, by stipulation, I would agree that on their face, they are sufficient for the next step in the process.
All right, Deputy Deal, can I borrow you for a moment, please?
Yes.
You would give 2 of those to each of the defense counsel and 1 to this, 2 of those to the state for me, please. Okay, so maybe it's a situation with this division, but this does seem a pretty fast-moving case. And there's not, as both parties I'm sure are aware, there's not a whole lot of case law with these issues. I was able to find a court order from Miami Judge Milton Hirsch, which I think is really, really well written. And so there are a couple of things from his order, which I just gave you copies of. I'm going to put on the record, and then I'll issue a written order later. I mean, he talks about, in the case that he had, which is State of Florida versus Charles Romero. It's a June 8, 2016 order, where the state was requesting an order to show cause for a witness or a victim that refused to appear. And Judge Hirsch goes through whether the court should go with indirect criminal contempt or indirect civil contempt, and there is a difference. On page 2, he talks about, and I'll read from section 2, paragraph 2, he says, to initiate criminal contempt proceedings is to initiate a criminal case. We'll drop down to the next sentence, next paragraph. As with any criminal case, the initiation of a criminal contempt proceeding may have collateral consequences. And then the final paragraph there. By contrast, the purpose of a civil contempt proceeding is to obtain compliance with a prior order of the court. And that is why I asked the state what their end goal was. Was it to punish the Donaldsons and to potentially make them convicted criminals as a result of the actions of this past week? Or was it to gain compliance with the court order? And so, indirect civil contempt, and Judge Hirsch goes through this, and like I said, I'm going to adopt a lot of his language in my order, but he goes through a lot of this. And with indirect civil contempt, there's a purge. The defendants do not become convicted criminals, assuming that would happen at the end. And I'll turn to, I believe it's page 3, the 4th paragraph, and he writes, the purpose of civil contempt is not to punish, but to coerce the contemptor to do that which the complainant, in this case the prosecution, seeks, and to which the complainant is entitled. And, is the state entitled to this? And the answer to that question, at least based on what the court has reviewed right now, the answer is yes. In fact, Judge Hirsch, if you turn to the first page, he talks about in the very last paragraph on the first page, and he references a second DCA case, Imperante versus Picola, Florida second DCA 1970 case, that the prosecutor can be a one-man grand jury. And the quote that he says further down, maybe the next page. Yes, okay, so Judge Hirsch writes on the top of page 2, and I'll quote Judge Hirsch on this. So far as I'm aware, this all but unlimited power, and he's talking about subpoena power, is exercised by no other prosecutor in the American system, not even an assistant United States attorney. So the state attorney's office has great power with these subpoenas. It's clear they have that power, and it's clear they can subpoena Mr. and Ms. Donaldson to answer questions. So at this point, that's what I'm going to do. And I will order Mr. and Mrs. Donaldson to appear before this court on, I believe it's January 5th is a Friday. Is that correct?
Yes.
I'm trying to give enough time with the holidays, and yes, January 5th is a Friday. Okay, so on Friday, January 5th, at 10 o'clock in this court, to show cause why they should not be held in civil contempt. Both Mr. and Ms. Donaldson can purge the contempt citation by appearing in the office of the state attorney at any time during the regular business hours in the intervening time period, and testifying truthfully under oath regarding this case. And I'll just follow Judge Hirsch in the bottom of his last sentence of this order. And the office of the state attorney is directed to arrange for the service of this order to be made on the Donaldsons within a reasonable period of time, and I'll write up the order.
Yes, Your Honor. May I ask one question of Your Honor
Sure.
when you're completed?
I'm done, yeah.
Finished, I mean. Upon our receipt of your orders in this case, and I guess this is indirectly directed to defense counsel, would they agree to accept service of those orders upon counsel rather than require us to personally serve Mr. and Mrs. Donaldson?
Yes, Your Honor, of course.
Great.
Thank you.
Okay. So, any other issues that this court needs to consider at this time?
No, Your Honor.
No, Your Honor, none from the defense.
Okay. All right. Thank you. Everyone have a wonderful day.
Thank you.
Thank you, Your Honor.